I'd like to introduce myself. My name is Howard Klein. I'm the founder and host of CRE Radio and TV, which I've been operating for about 10 years. I'm also a commercial real estate attorney, focused primarily on commercial real estate landlord-tenant matters, which includes evictions, rent collections, and lease negotiations. So let me move on a little bit and talk about what we will be discussing in this webinar. What we'll be talking about is why should landlords and tenants consider rent relief even when there is no legal obligation to give rent relief or where the tenant is legally entitled to rent relief. So we're talking about those situations in which the lease doesn't really help us and where maybe as a practical matter, the parties should be talking about it. In the context of planning a rent request for rent relief, what should the tenant do to maximize the rent relief requested or received? We'll be talking about that, how to go about doing it, and we'll be talking about how the landlord should respond. We're going to be talking about how to approach the landlord, and we're going to be talking about perhaps lease modification strategies for both the landlord and tenant, because they're coming from a different perspective, except they both have a common interest for the tenant to survive and collect rent. So before I go much further into this, I want to do a little bit of house cleaning so that everybody understands what we're doing here. I think the first thing that I should mention is that because Dan, who's the blue-looking person who's probably down below me, because Dan and I are both attorneys, and because we are doing this partly in order to acquire clients. I mean, that's really what this is about, so that we can help people. This may be considered attorney advertising. So if that bothers you, let me request that you stop watching this. We have had, or at least I've had, a tremendous amount of emails, people asking specific questions, and I wanted to explain something. In many instances, people have asked questions and they've sent me a copy of a particular provision in their lease. And I want to explain that I am not able to specifically answer specific lease issues, at least as part of this webinar. We are not providing legal advice. We're giving you a general idea of what's going on and what our non-legal advice is. This is what I've answered most people. And it's both an ethical issue and it's also a practical issue. We don't want to provide any kind of advice that people will misuse or misunderstand. So we're trying to make it as easy as possible to understand. And one of the things that I've indicated to people is that in commercial leases, we are talking about documents that are probably at a minimum of 30 pages long. And I've seen as much as 120, 130 pages. These are complicated, and I mean complicated documents. These are relationships that are often 5 years or longer. And there are different personalities involved. There are different financial considerations involved, many of which we're going to be talking about here. But it's nearly, I would be doing a disservice to everyone if I took one little lease or one little provision and said, well, I don't know who the parties are. I don't know what state you're in. I don't know what the laws are. I don't know what the other provisions of the lease provide. And I don't know the communications between you and your landlord. So here's my advice and good luck. I can't do that. And none of us can do that. We will, on April 2nd, do another webinar where we will be talking about specific lease provisions, such as the force majeure provision. Someone asked me about the condemnation clause. I don't know if that would apply. Uh, uh, Peter mentioned eminent domain, and my first reaction to that was, nah, not really, but he gave me some cases that made me reconsider my position. We're going to be talking about that on April 2nd. So those are the things that we'll be talking about then. And so now let me take the opportunity to introduce our panelists, and I'm doing it this time where normally I allow them to do it themselves. I think the first thing that I want to address is what is different from what's going on here, other than the obvious that it's about a virus, from other matters and or other recessions, should I say? Because we're going to have a recession. The only question is how short or how long it's going to be. To me, the real curveball in all of this is the stimulus bill that is being considered by Congress and hopefully signed into play within the next couple of days. I think it is very, very important. I don't want to get into discussions about who the money should go to. I think really overall the concept is everybody's going to feel pain. The question is if you can spread the pain out as broadly as possible, that everybody won't feel too much pain. And we're trying to save as many people and businesses as possible. As of yesterday, the Senate passed a bill. It sounds really good, but unfortunately, I don't know all of the details. Jerry might mention a little bit later on about SBA loans, and we probably will be talking about that, not so much today as we will in later webinars. But this is an unknown. And later in this webinar, I'm going to address a question, which is to what extent the landlord should be taking into consideration any relief that the tenants are getting from the federal, state, or municipal governments.
Or, Howard, if I may interject,
Sure.
With our Canadian friends, and I'm in Canada, the federal government in Canada also has unveiled a number of economic stimulus plans as well. And like you, I haven't had a chance to read all of them because they just came down this week after an all-night session of a truncated parliament. We only had a few people, part of social distancing, in there representing all of the parties. And so we'll also add in, what stimulus, what economic help is coming from the Canadian federal government, the provincial governments, and also municipalities as well.
So now let's move on, and I'm going to ask Jerry to start in with, when should tenants ask for rent relief? Maybe, yeah, Jerry, why don't you start with that? When should tenants ask for rent relief?
Well, I'll tell you what I've done so far with my clients. I've been sending out daily updates on activity, what we're finding from landlords. But I've actually, because in nature I am business, I'm actually the real estate department for small companies, a little different approach to brokerage rather than just transactional. So my phone, as soon as the governor made a statement about the virus and how it affects, my phone started ringing off the hook. I'm the first phone call. So I've talked to a lot of landlords already, kind of to tee it up, to find out what they're planning on doing. And I was very pleasantly surprised. All but one had an idea that they were going to move forward in a positive direction to help the client, because it also is, relationship based here too. One landlord, I won't go into that, but they had no idea. I've been fortunate that some of the landlords actually called me before they had their staff meetings to figure out what to do. So at this point, we haven't gone back and forth with the landlords as far as negotiations, although we've set a formula for how we're going to move forward. I think it's best to, hopefully you could approach your landlord. I would do it as soon as possible. Earlier the better, kind of like what your mother said there. The earlier the better. You don't have to put anything in place, but right now what I've done with my clients is created a framework.
Jerry, let me ask you this. Yeah, let me ask you this question.
Sure.
We already, prior to the beginning of the webinar, had a warning about this one. Should the tenant first stop or short rent payments?
My recommendation to him is no. Again, there are different, and again, I'm not an attorney, and I know you guys indemnified yourself as one, but there is some legislation, for example, in the state of California, the governor left it up to the local municipalities whether or not there would be any sort of an abatement or a hold off on rents. Los Angeles County, for example, was one of those that agreed to that. So you've got.
Harry, was that an abatement or a suspension of evictions?
It was both. It was a moratorium, actually moratorium on evictions, but kind of going with that, my knee-jerk reaction is, why would you evict someone if they're paying rent? I mean, so what would be triggered the eviction would be non-payment of rent. So if someone doesn't pay rent, the landlord basically can't evict them. That's kind of the way to look at
Peter,
it.
go ahead.
There's an issue though, and that issue is you have to look at the knock-on effect if you don't pay the rent. And I understand there's a universal problem that we have with this pandemic, and that is the ramification is nobody's got cash flow. And that's throughout the entire supply chain of the commercial real estate industry, from lenders and insurers all the way through to landlords, their tenants, employers, employees, and things of that nature. But the knock-on effect is this. If you don't pay your rent, and we'll talk about this a little bit more, and the landlord puts you in default, it could also affect other aspects of the lease, such as any rights and privileges the tenant might have for an option to renew or a ROFR or right of first refusal or something else. So I would be cautious about taking precipitory action. The one thing though, I do think, and I know we're not going to be talking about it in any great detail, but the one thing I think that all tenants should be doing is sending a force majeure letter to their landlord, because there's a couple of other things other than rent. They're not continuous operating, so that's in violation of the lease and technically could be a default. So send that off to the landlord. By the way, I think, and I'm going to take the landlord's position here, landlords should also be sending off force majeure letters to some of their tenants that have co-tenancy clauses, for an example, and they should be sending these off to their lenders as well.
Peter, you had mentioned earlier before we went.
Let me just a quick interjection here. My advice to clients, by which I think was your first question, pay the rent. Okay, don't get yourself into that situation. Pay the rent, and then let's figure it out as we move forward. Because right now, you're just talking about April rent, which is due any day now, and this impact really took hold 2 weeks ago. So we're looking at probably the May rent that's going to be really impacted. That's my impression. So
yeah, Peter, remind me to have you mention those 3 items that we discussed as soon as I'm finished with this comment. I'd like to make sure that everybody understands there's a difference between taking action to evict and taking action to collect rent. Mm-hmm. I've gone through many recessions, and many of my clients have been insurance companies, lenders, special servicers who during recessions where they've ended up with the property back, particularly with retail, but it also may apply to other types of property. My strategy generally was not to serve 3-day notices. when it came to retail, as I said, that was a special consideration. The last thing you want to do is empty out a shopping center. So where my clients, and most of them wanted to get rent, they weren't looking to evict tenants. We didn't serve 3-day notices. What we did was we started taking action to collect rent. And that was for tenants who actually were making money. They just simply had put us down lower on the totem pole, or put the landlords lower on the totem pole. So I had a practice of avoiding the mitigation arguments in litigation, which often were the most costly arguments in litigation. And then I would take action. I would file a lawsuit, sue for rent as it accrued, and then I would file something called a prejudgment writ of attachment, where I could attach the tenant's assets and accounts, and that usually forced the matter to settle quickly and push the landlord a little bit higher up on the totem pole. So that is very different from taking action to evict. Peter, if you would, you talked about 3 things that everyone should be paying attention to now. And if you would, please go to that.
Yeah, I think because this is a different time, and the one thing that people want in uncertain times is certainty, and obviously we can't provide that. But the one thing we should all bear in mind throughout the entire supply chain of commercial real estate is we need these 3 things. We need understanding. We need understanding of all the parties, their particular situation, what they're going through. The tenants need to understand what the landlords are facing. I mean, they're facing lenders that may be hardballing them as well. Then the second thing we need is open and honest communication. This is not a time for posturing. This is a time for showing all your cards, because we're all in this together. And yes, I mean, you don't want to put yourself in a disadvantaged position, but you also don't want to, hide anything either. And the last thing that is needed is accommodation by everybody. In other words, don't let one party hold the bag of the ramifications of this. Everybody's got a cash flow issue. I think that it should be spread out evenly, and that's to everybody that's part of the industry, from government all the way down to employers and tenants.
Now, next thing, Peter,
Yes.
Peter, Jerry, and Dan, remind everybody how to get in touch with you.
For me, it is greensteadcg.com. So GREENSTEAD as in cat and golf.com.
Okay, Dan?
They can email me.
Dan, pay attention.
I was quickly trying to generate a sign that I could hold up.
Dan is a member of the Blue Man Group.
You caught me. They can contact me via email at hotel, E as in Echo, D as in Delta, S as in Sierra, H as in Hotel, A, S as in Sierra again, T, E, another E, N as in November at gmail.com.
And Jerry, how do people get a hold of you?
Inhousecorp.com, INHOUSECORP.com, lower right-hand corner, all the information there.
And you can get a hold of me at HFK at HFKESQ.com. Jerry, why don't we talk a little bit about, let's see, from the landlord's, from the tenant's perspective. Mm-hmm. What are the negotiation strategies, and mention some of the modification terms that you are paying attention to?
Well, I guess if I'm trying to get the question, hands around your question here, Howard, what we're trying to do with our clients is create a framework, find out what the landlords need in order to move forward, and then, of course, what they are expecting from the tenant. I just want to address that, the last poll question. In retail and apartments, we have had some landlords who have actually come out first about this, and it has stirred up some interesting, sometimes negative reaction. On the other hand, we have most of the office landlords have not, they're waiting for the tenants to come to them, and then let's discuss it individually. Now, to answer your question, I think what are we looking at?
That's a good thing. What are you, a politician?
Yeah, sometimes. But as far as is what we're looking to do, I'll give you the formula. In fact, I jotted down a few notes of what landlords have already said and how we're creating it. Would that be helpful to everyone?
Yeah,
Oh, yeah.
Okay.
please.
Well, there's kind of 4 bullet points if people want to take notes. Landlords have said, first of all, one landlord said, "Oh, we have to have financials and we want to look at them." I said, "Financials don't mean squat because this all occurred 3 weeks ago. So why show 2018-19 financials? What you need is to know what is impacting their business right now."
Mhm.
So most landlords have agreed what they want from the tenant, not from me, from the tenant is a narrative of what happened. You know, you're a physical therapist and all your clients are over 65 years old and they're not showing up anymore. You know, exactly why you need the relief. The second thing, and again, I took notes and want to make sure, is what kind of relief are you looking for? Monthly, full relief, partial relief? How long do you want to have this relief for? And most important is, how do you want to pay it back? And we've created several formulas that landlords have willingly accepted and agreed to, that they would use as a policy in order, or as a structure in order to repay. What I tell clients, and I should allude to this, people, and the questions have come up on the chat and the Q&A already, difference between abatement and repayment, or whatever the term that they want to use, foregoing it to the repayment. Money is like, how would you say, energy. You can't create it, you can only change its form. So the whole idea, like we did back in 2008, 2009, you're recreating the money stream. How is it going to be paid back? So you might get some sort of, you might want to call it abatement now, but you understand the tenants, you've got a responsibility and you've got to pay it back. So those are kind of the things that we're negotiating and discussing with landlords, and they've been more than receptive to that. I've been very, very pleased.
Dan, from the landlord's perspective, and you and I, well, I'm going to be representing, and I am representing, some tenants as well as landlords, but you primarily represent landlords. From your perspective, how should the tenant first approach the landlord, and what should they provide?
Well, first of all, I'm going to have to take a little issue with what Jerry said. I think
we all are.
Right. Jerry, I think you're right. The historical financials may not be of relevance, except in this one area.
Mhm.
It may give you a trend to see what the tenant has been doing in the past, and also assets. I mean,
Sure.
because the bottom line is, if you're dealing with, multi-million-dollar, a tenant who's got a lot of assets, you may not want to give him rent relief, despite, going forward, his cash flow is poor. But he's got a lot of assets sitting in the bank, that might be a tougher sell. So that's why the landlords would probably want to look at historical information as well as a balance sheet.
Sure.
Just to see what sort of assets they have. I mean, quite honestly, and that's why, I haven't really interjected myself when we discussed the government policy, but I will just throw in this one comment. The reason why, whatever the government does with its relief, it's going to be over-inclusive, and it's going to not be narrowly tailored. And I think the watchword for these lease negotiations is every situation is going to be unique. It's going to involve a lot of time. There is not going to be one size fits all. And that's where I think the government is going to fail us, because they will impose a one size fits all and people will game the system. I guarantee it. I can already see it happening.
Yeah, it's spoken like a true libertarian.
Yep.
Dan, let me tell you something, and I agree with you. I've told landlords this because they wanted to know how I'm counseling my clients. And I've said to them, do not, take advantage of this. If you don't need relief, don't touch it, because it's kind of like the guy who goes into Costco and buys all that toilet paper that you can't find anymore. They don't need that much. It's going to hurt the guy who really needs it. So we're trying to narrow it down to, if you really, really need it. To answer your question about the financials, some landlords have said to me, even large landlords, that, hey, these guys have been paying rent for 4 or 5 years. They've never been late. We know their financials are good. This is a critical situation, just happened 3 weeks ago. So let's deal with what we have right now. But the advice I've given to clients is, yeah, Dan, 100% agree with you. You can't take advantage of it just because you think it's a free rent for 2 months or 3 months.
Isn't that a little pie in the sky?
Well, it's kind of like the social distancing, you
Okay.
don't lease it, but you're hoping that people will stay 6 feet
Peter.
away. Some don't.
I'll give-
Fort Lauderdale.
Peter?
I'll give one other thought when you're approaching the landlord from a tenant's perspective. And I'll look at this from the landlord's side as well. Just because it seems that with Jerry taking the tenant side in the discussion, I'm by default taking the landlord side. Landlords hate it if people come back to the well multiple times. So the best way to approach this is to work with the landlord on an overall plan that you can revisit, because frankly, none of us know when this is going to end. If you go to the landlord and say, I need 30 days rent relief, well, what happens at day 29 and we're still locked up and you can't do anything? So what I would suggest is that you work with the landlord, create a plan that can be modified over time and revisited as the needs are required. One other quick tip for you as well is if you have like a serious cash flow problem, you are probably not going to be able to pay April rent, suggest to the landlord, look, you have my security deposit, take that so you're not out of pocket for rent in April, and then let's talk about what we're going to do in the future. So, and then, obviously you're going to have to pay that security deposit back at some point in time in the future. But that just answers, a particular issue of, I have no cash as of today. So that's just one tip that you could do.
Absolutely. Peter, let me ask you this. Let me go back to what Dan was talking about, the need for financial documents. It's not just to determine whether or not the tenant has assets. One of the people who sent me an email, they wanted to know whether or not, who are the tenants who are most likely going to default. And before we even started the webinar, I had mentioned that, well, that's not my approach, is to start picking and choosing, but getting historical financials. If you've got a tenant who's been doing really well and paying rent and you know what their business has been like, that's a different situation. But getting historical financials will also help the landlord determine whether or not the tenant was already in trouble. And that should affect or may affect their decision on the type of rent relief and how they are going to negotiate going forward. So I think the historical financials are important. Yes, it requires a little bit more work, but as Peter said, everybody's butt is in a sling right now, and you really need to know what's going on in order to make decisions on a case-by-case basis, as Dan had indicated. So, Peter, I want to go back to you and ask you this question. What, from the landlord's perspective, what should the overall strategy be? And you might mention the difference between deferment and abatement, the recapture, and fixed dates versus other dates. Et cetera. And you already mentioned something about fixed dates. You want to have some flexibility, but go ahead.
Yeah, definitely want to have some flexibility because none of us know when this is going to end. So from the tenant's perspective, you want that. From the landlord's perspective, I know of one landlord in the United States that I believe has offered 6 months of deferred rent, but we don't know if it's going to be 4 months. So I am not a big fan of just saying, okay, this is the fixed date. We need a little bit of flexibility in there. Most landlords still have to make a mortgage payment. They're willing to help out, recognizing that in the grand scheme of things, this isn't going to last for years. It's going to last for months. And so a deferment is where you reduce the rent now and you pop it on the rent for the balance of term, starting at some point in time in the future. The one question that I would have if I was working for a tenant in this particular case is, what does your crystal ball say when we're going to be able to be in a position to be able to afford that? I might still be closed. So there has to be, as I mentioned, that flexibility. And a rent abatement, just a straight rent abatement, is that the landlord's forgiving the rent. And what they may pick up on the other side might be additional term, might be something that happens there. I have a friend, and he has just purchased a restaurant in the Bay Area in San Francisco, and he can't open. And so, he's willing to work with the landlord and pay rent like as soon as he can open, but he can't pay rent now, obviously, because he has no income whatsoever. So I think flexibility is the key there. Some other things to bear in mind is from a landlord, they may ask for some takebacks in the lease in order to provide you with what it is that you need now, basic horse trading. They may ask you to exercise an option now so they can go to their lender and say, I have these tenants here today, because lenders are going to be a little skittish as to the income stream for the landlord as well. So that's not an unreasonable thing. But the one thing I would always caution people is to watch out for the back end of this. For me, because I've also represented tenants in all of this, I've suggested a conversion to percent rent. And by converting to percent rent for a period of time, if there's no income coming in, there's no rent being paid. And then the landlord has the option to be able to recapture some of that deferred rent later on. But what it does is it takes out of question also the ramp up on the back end. Because when this is over, it's not going to be back to business as normal right away. People are going to have to ramp up. So there's still going to be a little bit of a problem in paying the rent, I think, in maybe the first month, maybe 2 months after the pandemic has been called off.
You had a comment?
Something you brought up about the lenders. I think from what I see with the tenants, they don't understand all the stuff that goes on in that back room of the landlord, including the mortgage and things like that. There was a posting on CoStar, I think yesterday, an article that I saw in Houston where they signed 2 or 3 leases and they were rushing, and they gave the tenant like a 10% discount off of what was already negotiated. And my knee-jerk reaction was, it's probably because the lender was putting pressure on them to have the building, occupied. From the tenant perspective, or tenant broker who was posting it was saying, hey, look, it's a tenant market. You could go out and get these great deals right now. Well, I think there's, again, you got to look at the global picture, the whole thing. You can't look at just your little narrow box as being a tenant or being a landlord. And I think that's what's happening, is we're getting cooperation that we, had back in 2009 when, we had a crisis, but this is so much different than anything, but it's same but different.
Two quick points that I just wanted to finish off on, and that is what happens if the tenant then defaults on the lease afterwards. And so there should be a provision in, as we do this, I think we're going to see lease modification agreements, and they may be as simple as a 1-pager, because some landlords are going to have hundreds of tenants to deal with. But it should be that if there's a default, the amount of deferred rent would be immediately payable. If that default happens to be financial, obviously. There are other protections that landlords can put in. They can set it up as a loan. They can do it as a PPSA in Canada. I don't know if you have the same thing in the United States. Personal Property Securities Act, where they take out a charge against inventory and chattels and things of that nature. So there are ways that landlords will be able to protect themselves with respect to these deferred rents. And I expect them, and tenants should expect landlords to put those protections in.
Yes. I'd like to, just from the 36,000 foot perspective, I'd like to address this issue. If I were representing a tenant, I would want the landlord I would ask the landlord to forgive rent, and that I wouldn't have to pay it back later on. Honestly, that's where I would start, because that's the best case scenario for the tenant. If I were representing the landlord, I would say, okay, I'm not going to forgive rent, or at least as an attorney representing a landlord, I would say, look, don't forgive rent, kind of defer it, pay it off, do all kinds of other deals. Let's work the best deal we can, because from both parties' perspective, they're looking for some sort of control. And so everybody's going to be giving something up. And my attitude is, if I'm representing the landlord, I want to give the landlord as much flexibility. If the landlord later on wants to forgive rent, go to it. It's a business decision. But I don't want to give that away up front if I'm representing the landlord. And just the opposite for the tenant. Dan, why don't you just mention something about recapture on either rent that is forgiven or rent that is deferred?
Yeah, typically, even before this crisis occurred, and once again, I deal primarily with retail tenants, so I'm talking about restaurants and other stores. When we gave rent relief, and what I should say is free rent. So typically, retail tenant, will come to the landlord saying, when I open the store, I need a couple of months of free rent while I get ramped up, and landlords will grant them the free rent. But one of the things we do it is an abatement, but it's a conditional abatement. So the rent is forgiven provided that they abide by all of the other terms of the lease. And so we kind of hold this as a sort of Damocles over their heads. So if they were ever to default, and this goes back to what Peter was saying, and I think Peter made some excellent points there, that whenever the tenant defaults, then we can recapture that deferred rent. And so that was done for many years prior to this crisis. So this is a concept that landlords will be familiar with, and if tenants propose it, I think they'll be very likely to take it. The other thing I want to just apprise you of, I mean, I've been dealing with this issue for the last 2 to 3 weeks as well, and I want to emphasize the importance of percentage rent and that as a concept. And I think Peter mentioned this as well, because what you need to do, and I think we've discussed this a little bit, we've got to try to spread the hardship here. Now, I don't want the government to spread the hardship, but I think the individual parties can do a better job of spreading the hardship, and that's why I like the concept of percentage rent. And Peter's comment about the period during which that percentage rent occurs obviously needs some definition, but the concept itself just seems to me pretty valid. And what tenants should do is they should look at their individual industry, because there are guidelines for what sort of percent of your gross income a tenant should be paying. I know in the restaurant industry, for example, there are guidelines, and you can Google this in 2 seconds. Generally speaking, restaurants look for a ratio of 5 to 10% of their gross income should be paid in rent. So that gives you a perfect guideline of how much you should offer the landlord, between 5 and 10%. And then it becomes a matter of individual negotiation.
And let me add something, a couple of things. One is, when you're renegotiating things such as percentage rent or forgiveness or abatement or deferral of rents, I think it's best to negotiate something where there's a triggering event, where the landlord and the tenant both know when things are going to change in the future. And it could be a lot of things, where the state government or local municipal government changes some of their regulations, or based upon certain income levels. Percentage rent, talking about percentage rent, for those of you who are not familiar, that's very common in retail properties. And when I'm representing a tenant and they see a percentage rent provision, yes, we research what the percentage is typical in the industry, but I often tell them, when they get outraged over the fact that there's a percentage rent provision, I often tell them, think of it this way: figure out what percentage what the triggering percentage is where you would be thrilled to pay the landlord percentage rent. And that's usually the guideline that I use to help tenants. But it's different for office and industrial. Office and industrial do not typically have percentage rent. So if they're going to do that, they're going to have a whole different provision to deal with that they're not accustomed to.
Dan, I know you're not an insurance person, and I am going to sort of throw you a little bit of a curveball here. But what I'm hearing is, from the landlord's perspective, rent loss insurance isn't going to be covered by the insurance because there isn't a physical casualty. And Jerry, maybe you can touch on the tenant side with business interruption insurance and what you're doing.
I've done a lot of research on both.
Let's start with Dan first, and
Yeah.
then we'll come to you, Jerry.
Sure.
Yeah, I really can't speak to that issue. I haven't looked at it, so maybe we should go to Jerry.
Okay, sounds good. Jerry, what are you hearing?
Yeah, no, I basically, from all the insurance coverage attorneys I've talked to, and also the insurance agents, I actually took down some notes on what they've said. Basically, everything is triggered by what they call a covered event. So if it's not covered in the normal policy, for example, there has to be physical damage to the property. If loss of rent, one of the insurance agents I spoke with this morning in preparation, we equated it to 9/11, where you have a building down in Wall Street, your building wasn't, taken down in the disaster, but you're next door and you can't go into the building. You have, less than 50% occupancy or whatever, you can't get into the building. That might trigger the rent loss insurance. But quite candidly, I had someone who, an email was sent to me where somebody was doing some solicitation as a broker to try and get into, using it as an opportunity. And they're saying, oh, well, your landlord's going to be paid on rent interruption insurance. Well, no, that's been flat out. Call your insurance agent, ask them if you're a landlord, call them, have them go through your policy, but most likely there's an exclusion for things like this. And again, the key thing is it has to be triggered by what they call a covered event. If not, even what do we call it for the tenant, business interruption insurance or rent insurance for the landlord. So on both sides, it's got to be a covered event. And this is not. I will say by the way, this just came out and this insurance agent just sent it to me. The state of New Jersey, there's a bill in front of the state of New Jersey. I took notes about it, but it's going to eventually cover this loss. This is going to be included in policies. And it hasn't been, it hasn't been approved yet, but it's in the New Jersey legislature. So maybe others will follow. So long-winded answer to your question, but talk to your agent, likely not covered.
Yeah, I was talking to a lawyer myself, and that particular lawyer said, there really should be a form of insurance to cover something where everybody has no income and there is no cash flow. There isn't, and frankly, to be honest with you, I don't see insurance companies doing that. They're being hammered with natural catastrophes and things of that nature. And they're on financial thin ice already. Dan, let me ask you, from a landlord, is it reasonable to expect the landlord to look for a guarantee, at least for the deferred or abated rent?
Oh yeah, definitely. If there's a guarantee involved, they will look for the guarantor to make good on whatever, losses they have under the primary lease. And in fact, as a general rule, when we amend leases out here in California, no matter how we do it, we always get the guarantor to sign off on that so that we don't have any issues about the guarantor saying, oh, I guaranteed the lease as unamended and you went and, changed my obligations. So yeah, landlords are very sensitive to that issue and will try to keep the guarantors on the hook for as much as they can. Now, that being said, that doesn't mean you shouldn't ask if you, as part of your abatement or deferment package, you shouldn't ask for, some help for the guarantor too.
Yes, and how about in the situation of, and I'll leave it open to either Jerry or Dan, the case where you have a lease and then a sublease, so you have a subtenant. That complicates things just a little bit more, doesn't it, Dan?
Well, we actually like that because there's more parties on the hook. So, instead of just having one tenant, now we can possibly, if they did an assignment, we can look to two entities. If they did a sublease, we would just look to our tenant and then expect our tenant to do whatever they need to do with respect to their subtenant. So there is a legal distinction between an assignment and a sublease. And with assignments, the critical issue is whether the original tenant was let off the hook and you have basically a substitution of one tenant for the other. I'll tell you, here in California, the common practice is never to let the original tenant off the hook. You always keep them on the hook, as well as the original guarantor. So yeah, so you could have this issue, and I've got clients, and I've been on the other side too, where you have a lease, it's guaranteed by an individual, they sell the business, they do an assignment, of the lease, the guarantor does not realize he's still on the hook to guarantee the lease with the new tenant. So just some things to be aware of.
You know,
Slightly off topic, and I know Jerry wants to jump in here, but slightly off topic, but on topic. Be aware on assignments that the assignor and the guarantor could be on that hook, that liability hook, ad infinitum. So it's always good practice to make sure it's for the one assignment only. Jerry, you wanted to say something?
yeah, I was just saying, I was just looking at the chat thing here. A question came up earlier about could you renegotiate your lease? And then someone just popped in a question about, hey, if you're near the end of the lease, is this a good time to renegotiate? Because that was the question, can you renegotiate a lease to do a new long-term lease? And my answer on the chat was, probably not. But then I thought about it a little bit. And the reality is, yeah, if I've got, 6-8 months left, 10 months left, maybe, or whatever, and we need some relief, and I have an option, maybe this answers the question for the person who asked me. Yeah, I'd go back to landlord and say, hey, look, I got an option. It's 8 months down the road. Let's negotiate it now, which we usually would do 8 months out anyway. And we'll extend it for a new, 5 years plus the 8 months. And we'll spread the term out a little bit. Maybe we'll give some free rent now, which will be part of the new term. I've got one client who we just signed a new extension about a month ago, right before this happened. And they have a couple months of free rent coming in the new lease, which starts, I think, in June. So what we're looking with them is, let's take those 3 months of abatement, give it to them now. And then when the new lease starts, they don't have the abatement.
Right.
So there's a lot of ways to, you got to think out of the box. That's all I could say to anybody on this webinar. Think of what you need, think of what the landlord needs, think out of the box. Don't just go by, okay, this is the formula. That's, I think, the message I'd like to share with everybody.
All right, guys, I'm going to start. We've got some questions here that I think we ought to answer. Plus, there have been some people who've raised their hands that I'd like to bring in. So why don't we start with, did this start early? Oh, no. Yes, it did start early, but don't worry about that. Go ahead.
Yeah, let me just jump in here quickly.
Go ahead.
When you talk about bailouts too, another critical factor of a bailout, not only the amount of money that we're throwing around, trillions of dollars, but timing is going to be critical too,
Sure.
Right? Everyone's talking about, there's going to be this Deus ex machina coming from heaven, trillions of dollars raining down on us. Well, I won't go into the knock-on effects of that, but one of the immediate effects is the timing. We're talking about issues that are going to arise in the next 2 months. I will be surprised if you'll see checks, or you may see checks to individuals. They're talking about $1,000, $1,500. But when you're talking about major subsidies done, you're probably looking at several months down the line. So this is an issue that's not going to be cured by massive government bailouts to anybody.
Yeah, I think that's
any
true.
country.
Go ahead,
In any
Right.
country. In any
Right.
country.
Yeah, there's just not enough people to handle the requests, and it's going to get bogged down. I don't think there's any question about it. But if there is some sort of relief for landlords, it's going to be some sort of moratorium on foreclosures, which of course then the lenders and the people who've been involved in like CMBS loans, those people are going to suffer. So we're going to have to figure it out. A bailout really is important. And yes, I recognize that this may be later rather than sooner in terms of getting that relief.
Howard, just to jump in, I see a question here on the chat from Doug. He was asking about the landlord wants some sort of a plan to show what suppliers and people down the road that you have a plan to survive, like we're talking about guarantees and things like that. And I think this is part of what I discovered in talking to landlords up front, that the narrative is extremely important, I have my clients send me their narrative that they want me to bring, and I'll edit it and go back and forth. So that is all part of that narrative. What's happening to your business? Why is it breaking down? What's happening to your supply chain? I got a call from a client down in Atlanta. They're a consulting firm, and everything that they're doing, all their clients are saying, hey, that project is off because people can't come into the, to do the work. So therefore we can't do it. So that's really critical. Got to have landlords want to know what the plan is.
Yeah,
Absolutely.
I'll give a quick shout out to Doug as well, because he's a personal friend of mine and he's currently in New Zealand.
I want to hold that against him.
He's a tenant rep guy as well. But he brings up another point, and you didn't get a chance to touch on it, Jerry, but I will, and that is when you're talking about the narrative, who all is feeling the pain?
Yeah.
Landlords don't want to just see that they're the ones that are going to be feeling the pain. As part of the narrative, the tenant should say, this is what's happening with all of my suppliers. This is what I'm doing with all of them. I had one person ask me, well, how about franchisors? What are they going to do? Should they be giving up their franchise fees? Well, fact of the matter is, for most franchises, yeah, you give up the franchise fee because there's no money coming in. It's usually a percentage of the revenue that comes in. So yeah, they're going to be giving it up. So yeah, as part of that narrative, make sure that the landlord understands that you aren't just looking to them, you are looking across your entire business.
Yeah. Let me jump in here quickly too, guys. One thing that I think it's important for all sides to realize, and maybe I'm going to be divulging a landlord secret here, but you have to understand where the landlords are coming from and what their alternatives are, right? So everyone thinks a landlord is Simon Legree. They're just anxious to put tenants in default, right? We're just waiting for you guys to screw up so we can take back the premises. I'll tell you, they are not. They are looking for cash flow. So they are not anxious to kick you out. And here's the thing we all need to consider, right? What is the landlord going to do with an empty space?
Exactly.
There's not. Jerry's doesn't have clients clamoring for new space. Landlords don't have prospective tenants clamoring for space. So landlords kicking an existing tenant out who only cannot perform because of this extraordinary event, they aren't excited to kick you out. So they're going to be interested in working with you. And so, you need to understand the landlord's incentives. And that's why, as I said, this needs to be taken on an individual basis. If you understand that the landlords, want to keep the cash flow, any cash flow, because right now they're looking at zero cash flow, right? And that's why the percentage rent concept and ideas like that will be appealing, because getting 100% of your contract lease rent, requiring 100% of that being paid, but actually collecting nothing, is a worse outcome from the landlord's perspective.
Yeah, I gotta agree, Dan. When I was one of the large landlords I spoke with, that was the first thing that they said. They said, well, what am I going to do with an empty space? I don't want, I got a tenant who's been here this is where I talked about the financials earlier. I've got a tenant who's been here for 10, 15 years. They've never been late on their rent. I know they're solid. Why would I want to, kick them out or whatever? I understand that their business went from 100% to 30%. That's, again, where that narrative comes in. And I agree, the whole supply chain, everyone who's feeling the pain, in counseling, back in my old days, it was always, let's understand the problem before we could solve it.
Yes.
And that's the key thing, understand all aspects of who's feeling the pain, what needs to be done, and then how can we resolve it so everyone feels comfortable. And this is really a personal, even though it's a business issue, it really narrows down to, people, and people have to work together to figure out how to come, how to resolve this issue. And I think I'm delighted that all the landlords I've spoken with have jumped on board and said, hey, let's work with you. Let's figure it out. Let's make it work. And again, we're only 3 weeks into this crisis, if you want to call it that. And we don't know what May, June, July, and August are going to bring.
Okay. Can we be evicted in a time like this if we don't pay rent? Let me answer that. To the extent, if a governmental entity that has the ability to restrict evictions, if they haven't restricted it, then the answer is yes, you can be evicted. But as everybody's been talking about here, landlords generally are not rushing to the court. Not only that, let me add, many courts are closed and that are not taking new business. So even if a landlord wanted to evict a tenant, they may not be able to do so, or it's going to be delayed. There are a lot of issues there. I really, the purpose of this webinar is not to talk about evictions, but trying to get everybody to work this out and give some of the strategies. So that's my answer. Does anybody have anything to add about that?
No, but I saw a great question from Sasha that I want to address. Sasha asked, do you have the best approach to reach out to a landlord, email, letter, phone call? And I think Jerry would agree with me on this one. This is not a time for impersonal emails or text messages or letters. There's a place for letters, and there's some letters that you should be sending out, such as the force majeure notification letter that I mentioned before, that we're going to be talking about on April 2nd. But aside from that, if you're wanting to do a rent program with your landlord, put together the package, put together the narrative, as Jerry calls it, have that in writing, but pick up the phone, call your landlord. They want to hear from you. You want to talk to them as well. So much can be misinterpreted in an email or letter. Just make sure. This is very personal right now for everybody. It's very personal. So do that.
Yeah, that's the reason I got on the phone yesterday and spoke with them, probably 16, 17 landlords. And
here's a great question from Robert Eisenberg. What safeguards are you building into deferral agreements to protect landlords in the event that tenants receiving rent relief go bankrupt after receiving the benefit of the agreement, but prior to repayment? That is a great question. And that actually goes to the issue of, whether or not you can put into an agreement, you can't seek, people have tried that the lease will be in default if the tenant files bankruptcy. You can't do that. It's not an enforceable provision. That's number one. What we have done at times when I've entered into settlement agreements, court agreements, or other kind of settlement agreements with tenants, it really depends what you try to do, among other things. And I'm going to have a bankruptcy webinar in a couple of weeks talking about this specific issue. What we have generally done is have the tenant make representations to the landlord with regard to their financial position and whether or not they have any intention to file bankruptcy at that time. And there's some question as to what extent it's enforceable, but if the tenant provides fraudulent financials, then you could find the tenant and the obligation non-dischargeable in bankruptcy. But again, bankruptcy litigation is an expensive proposition.
But as we said before, Howard, there's also other solutions for the landlord to protect, such as, even if there isn't a guarantee on the lease, at least get a guarantee for the deferred rent. So that there's another party on there. There's all kinds of other things, such as making it a loan as well, that you can charge on. A secured loan.
A secured loan. And what does a secured loan do? Why don't you answer that? Because I know the answer.
Yeah, well, Dan can answer that. He's the lawyer. You're the lawyer. I'm just a lowly advisor. So I don't want to hog all the airtime.
Dan, you go ahead. You answer it.
Well, I mean, it gives you certain rights in bankruptcy, right? Your preferred, I guess, creditor. To use the term.
If there are assets.
If there are assets, right. And it gives, obviously, it gives you a pot to look in that's hopefully segregated from other assets, so that you can try to collect your debt against it. So,
for those landlords who will consider a security interest in the tenant's assets as part of the agreement, let me add, and I have litigated this issue, let me add that you need to perfect that security interest. In some states, it may be just by entering into the agreement. I don't know of this, but just by entering into the agreement, you may be perfecting it. I don't know the answer to that. I do know that in many states, the bankruptcy courts will look to the law of the state in which the transaction occurred to determine whether or not that security interest is perfected so that the landlord's interest is protected in bankruptcy court. Many years ago, when I was general counsel for Big Bear Supermarkets, I came in an instance in which the prior general counsel, and this may be the reason why he had to leave, failed to perfect a security interest, and it cost the supermarket quite a lot of money. So I was fortunate to learn that lesson very early on in my career.
Howard, may I do one of the
Absolutely.
questions here?
Sure.
This one comes from Mike, and he said, and it's a little long, but I think it deserves to be read. As a retailer in a mall, the implied agreement is that I'll pay rent for a space that has traffic, shoppers, complementary businesses.
I'm reading that question right now, and it's a great question.
Yeah, my store is closed now, as are others around me. There's no traffic in the mall. The landlord is now not delivering the product that I agreed to rent. So why should I pay for a service that I'm not receiving? It's like continuing to pay for an insurance policy that has been canceled. I will never recover the lost sales. Why should I have to pay for a service for a period that isn't being pay for a service for a period that isn't being delivered? And Mike, that's the whole basis of getting a rent deferral, and I know you're going to say, well, look, I'm still paying for it. I'm just paying for it later, but a rent abatement. But let's be clear here, and I'm going to put on my landlord advisory hat. The tenant is not paying for traffic, shoppers, and complementary businesses in its rent. What it is paying for is to occupy space. That's the concept of the lease. So it's a little harsh to say what I just said, but that is functionally what it is. All that other stuff is what you hope to gain as a benefit for renting the space. But what you're paying for is to rent that space.
Peter, let me add to that. There are exceptions to that rule. And there are a number of different arguments that can be made, of which we will be discussing this in next Thursday's webinar. I mean, there are legal concepts called frustration of purpose, impossibility of performance,
Quiet enjoyment.
Quiet enjoyment. Oh my gosh. And let me give you an example of a situation. There's a very well-known major mall in Southern California called South Coast Plaza. And before there were any orders from the government to, while there were suggestions of social distancing, at about the time there were suggestions of social distancing, I believe South Coast Plaza actually closed the mall. It took its own affirmative action to close the mall. And I would take the position that if I were representing a tenant, that this is a violation of the quiet enjoyment provision where that's occurring. If it's a situation where, you know, for whatever reason, people aren't coming to the mall, but the mall is open, that falls more into your situation. But there are situations, and this is the larger malls, any place where there's a large congregation of people, and I'm going to be writing a separate article on this, where, you know, for the last 8 or 9, 10 years, mall owners have been really, and shopping center owners have been really pushing this experiential to get foot traffic, to bring as many people to their shopping center as possible. This is going to cause a kink in that strategy, because even if the federal government or certain governments say, okay, there's no longer an order to stay in place, people are going to be reluctant. It's going to take a while before people are going to be hanging out in malls.
Jerry, I'm gonna co-moderate this part. There's a great question here I'd like you to address because it's bang on. You guys haven't talked about how the tenants are going to be paying property taxes, common area maintenance, and utilities. Want to address that?
Yeah, that's why I was going to ask that, because I see a lot of people have asked that question. This is personal opinion here. If you're in a triple net building and you're responsible for taxes, maintenance, and insurance, different landlords structure triple net leases differently. In most cases, you pay the landlord, the tax portion, and he actually pays it because the landlord wants to make sure that the taxes are paid and not just give you the bill and say, here, take care of it. But you're talking about the government entity. You're not talking about the landlord. So that issue probably has to be addressed now, directly with the county or whoever collects the tax. Now, the maintenance, the common area maintenance or the other stuff, you probably are required to pay for it. But, here's a thought that I don't think anybody's thrown out. Let's say you have a parking garage and you're paying for your parking. You have 50 employees and you have 50 spaces you're paying for, but only 10 people are coming into the office. I've had landlords who have actually said to me, if I were your tenant, I would suggest let's get rid of the parking charges. So, if you're talking about common area fees, those fees are actually going to go down because you're not utilizing it, your electricity, et cetera, et cetera. But parking is actually something no one's touched about. And I've had, actually 2 or 3 landlords say to me, hey, that's the first thing. And now parking is usually a separate, in Orange County, you have a parking vendor. It doesn't go through the landlord for rent. Some landlords in LA own their parking garage, so it may be easier to negotiate than here. But that's something, how many parking spaces are you going to be using for the next 3 weeks? Maybe you could get some abatement there too.
Darius has a great question as well that I want to throw at Dan.
Yes, I was gonna point. This is an easy one to answer, but
this is an easy one.
Yeah.
This is an easy one, Dan.
You're really putting
Darius,
pressure on me here. Jeez, I hope it is easy. Gosh.
Darius asks, this has been very helpful. Thank you. Oh, thank you very much, Darius. I wonder if the landlord provides verbal authorization for a rent deferral now, and then at a later date in the future, there is some disagreement or falling out. Can the landlord use this default on payment against the tenant for a later unrelated issue?
Well, generally
We're not
speaking,
belittling you, Darius, but for the 4 of us, this is a real simple answer.
yeah, I mean, generally speaking, landlords don't like to enter into verbal agreements, or I guess here this would be an oral agreement. So that's why, Peter, I think earlier you said, get on the phone to talk to your landlords. I will tell you, some landlords are gun shy about doing too much negotiation over the phone because tenants and everybody, we all do this, right? We only hear what we want to hear. Yeah. So when the tenant throws out, oh, you're going to discount my rent by 75%, and the landlord maybe responds not as clearly as he should have, well, the tenant's going to go, hey, I just negotiated a rent reduction of 75%. It goes on his way, and then you have litigation when the tenant tries to enforce that. So I think, as a lawyer, right, I deal in writing. So I say, yeah, get your presentation ready. And if you have any proposals, put them in writing and get your agreement in writing. Don't rely on anything that's oral, that we're going to have a he said, she said situation. That's a general rule for whatever your business practice is, not only in this specific situation.
Yeah, there's going to be modification agreements everywhere.
Right.
Oh yeah.
A lot of lawyers are going to be very, very busy.
Oh yeah. Oh, absolutely.
Yeah, we'll be busy, but we won't know whether we'll get paid.
That becomes another whole issue, and
right.
I'll instruct other lawyers on what to do to make sure that happens. With that being said, let me add that unless the lease provides otherwise, at least in the United States, an email is a writing. Mm-hmm. So if you have an verbal conversation with your landlord, or the landlord has a verbal conversation with the tenant, confirm it via email, but you do need to consult your lease to see if you can do that, because some leases exclude emails as a writing. Mm-hmm. So you do need to review that. And again, of course, you could hire any one of the 4 of us to review your lease. I got to tell you, I know that this sounds, of course, you're a lawyer, But if you understood that we want to give good advice that works, that's effective, and maybe very early in my career, I could have off the fly just give a edict. This is what you need to do. Really getting all of the information, particularly with these large leases, and from someone who has had commercial lease experience. Don't just hire any lawyer. Don't hire your divorce lawyer to do that unless he's got commercial lease experience. Don't hire a residential agent to negotiate this on your behalf. This is specialized stuff, and a lot of people don't even understand the language. And frankly, if I have to read a 60-page lease, and I've told someone else and they laughed, I fall asleep somewhere in the middle of the 60 pages, or my eyes glass over. And I've developed a method that I have to stick to make sure that I understand everything. I take into consideration that I'm a human being, and all four of us do that.
You know, Howard, one thing you said, which I think has to be absolutely emphasized in a situation like this, you've got to find which is what I've been doing for the last, 2 weeks here, talking to professionals in each area. I'm not an insurance defense attorney. I'm not an insurance agent. I'm not I could go on. I've even had calls from a couple of security people because, there's security issues. There's a lot of fraud going on, cyber fraud. What if happens if you're in a sole occupant of a building and you have to send everybody home? I've got a client who is an armed guard who will supply armed guards. I mean, that's kind of extreme, but I have to say that you really have to get professionals who are professional at what they do, whether it be I'll even break it down. Maybe I'm pontificating a little bit, but as a tenant broker, and I think that we have several tenant brokers on line here, we look at things different than a landlord representative who's trained to look at it from the landlord's perspective. And Peter, you and I have discussed things that we have different perspectives because you're mostly on the tenant side, Dan as well, Howard. So that's something I think, if another message, get professionals right now who specialize in the area that you have a question. I can't review the force majeure clause. I could look at it, I can make sense out, but I asked a dozen attorneys to look at it for me. And, I've gotten that advice. So, that's a takeaway for people, I think.
Absolutely. Listen, I've reached out to attorneys that I know who specialize in insurance and insurance defense work, because I hate looking at the insurance provision in a lease, and these people know it. So I've reached out to them. I can give advice on general business matters. I've been around a while, so I can help guide people. But I'm not going to give you insurance advice. I'm not going to give you advice on auto accidents or anything like that, and other types of liability. So yeah, get someone who knows what they're talking about. Gentlemen, we are going to have to wrap these things up. I would like to thank the attendees. And Peter, why don't you start out? How do people get a hold of you?
Best way to reach me is through the contact information on my website. That website is www, of course, Greenstead CG, C being consulting, G being group.com. Let me spell that for you. GREENSTEAD, C as in cat, G as in golf.com. And I see Dan's making up his sign.
Go ahead, Jerry, since Blue Man is looking aside.
In-house Corp, one word, INHOUSECORP.com. And my phone number's there. A couple of people have already asked about it. If you'd like to give me a call and spend a couple of minutes, I could kind of give you a little bit of update, especially tenants. Those are the ones. But landlords, if you have issues, by all means, I could give you some feedback on what tenants are looking for. So I'd be glad to help. This was wonderful. Thanks, Howard. I really appreciate it.
Dan is already showing a blue sign. That's HED Shasteen. That's SHASTEEN at gmail.com. And you can get a hold of me at HFK at HFKESQ.com or Howard at CREradioandtv.com. Thank you, everybody.
Thank you.
Yeah, you can all say thank you. You're allowed.
Thank you. Take care.
And that's a wrap.